Good morning. My name is John Rhodes. I'm chair of the Public Service Commission and also chair, in this case, of the Board on Electric Generation Siting and the Environment. And I'd like to call this meeting of the Board on Electric Generation Siting and the Environment to order. Before we get started, I'd like to note our arrangements for the meeting today. In line with the guidelines concerning social distancing and minimizing large gatherings, and in keeping with the executive order suspending provisions of the open meeting law on an emergency basis, we are conducting today's meeting remotely. I'd like to remind those who are participating by phone to please mute their lines except when they are speaking. The public will have the opportunity to listen to the meeting by going to the department's webcast page, and we will also record and transcribe the meeting as has been our practice. These arrangements have been reviewed by our general counsel, and he has found that they meet the requirements of the executive orders and that they meet my own expectations of honoring the intent of the open meetings law. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the siting board. And as I call your name and introduce you, could you please say here or present or some other confirmation that you're on the call. Louis Alexander, alternate of Basil Sagos, Department of Environmental Conservation.
Present.
Thank you. Dr. Elizabeth Lewis Michael, alternate of Dr. Howard Zucker, Department of Health.
Present.
Thank you. Vincent Ravishir, alternate for Eric Gertler, Acting Commissioner, New York State Department of Economic Development and President and Chief Executive Officer Designate, Empire State Development.
Present.
Thank you. John Williams, alternate of Richard Kaufman, New York State Energy Research and Development Authority.
Present.
Thank you. And I'd also like to introduce the ad hoc member of the Alley Cat Article 10 Siting Board, Christopher Muller.
Present.
Thank you very much. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you very much. So we'll proceed to the agenda, to the regular agenda. Case 17F0282, application of Alley Cat Wind Energy LLC for a certificate of environmental compatibility and public need pursuant to Article 10 for a proposed wind energy project located in Allegheny, Cattaraugus, and Wyoming counties, New York, in the towns of Arcade, Roseville, Freedom, and Rushford, presented by Dakin LeCakes, Chief Administrative Law Judge, Department of Public Service, and Greg Sayer, Administrative Law Judge, Department of Public Service. Michael Caruso, Administrative Law Judge, Department of Environmental Conservation, James McClymans, Chief Administrative Law Judge, Department of Environmental Conservation, and Robert Rosenthal, General Counsel, are available for questions. Mr. LeCakes and Mr. Sayer, please begin.
Thank you, Chairman. Good morning, Chairman Rhodes and members of the Siting Board. You have been provided with a draft order that, if adopted, will grant a certificate to Alley Cat Wind Energy to construct and operate a wind generating facility in parts of Allegheny, Cattaraugus, and Wyoming counties. The certificate is conditioned on the developer's compliance with certain requirements that have been established in precedent dating back to when I first appeared before the board in the Cassadaga wind matter in January 2018. Specifically, the board's environmental and public health and safety conditions in areas such as wetlands, endangered species, noise, and operational matters continue to be applied to ensure that the interests of New York State residents are protected as this state moves toward achieving its renewable energy goals. Appearing in this case as an issue of first impression is the seismology of the project area, which is situated on the Clarendon-Linden fault system. The order requires further study in Alley Cat Wind's pre-construction geotechnical report of that fault system and its potential impacts on the wind turbines, thereby ensuring to the maximum extent practicable the facility's ability to withstand seismic events. Another area of first impression for this project concerns its proximity to a designated environmental justice community. Environmental justice considerations include ensuring the fair treatment and meaningful involvement of all people, regardless of race, color, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. The draft order adopts the recommended decisions finding that the environmental justice community will not be subjected to a disproportionate impact by locating the project facilities therein, and that any impacts there have been minimized and mitigated to the maximum extent practicable. Turning to environmental considerations, for state forests, the draft order establishes minimum setbacks of 1.1 times the turbine tip height from the forest boundary to minimize the potential adverse risk from a turbine collapse or ice throw condition to the public enjoying the use of the state forest. As an additional benefit, this setback results in the project meeting all applicable noise standards at the forest boundary as the sound attenuates over the intervening distance. Thus, the order determines that no additional noise limit at the forest boundary is required. With respect to bats, following siting board precedent, the draft order provides Alley Cat Wind an opportunity to demonstrate during the compliance phase that the board's 6.9 meters per second curtailment regime should be modified where the applicant demonstrates that that regime jeopardizes project viability and where Alley Cat can provide a satisfactory net conservation benefit plan in consultation with both the Department of Public Service and the Department of Environmental Conservation. Finally, the draft order concludes that based on the entire record of this proceeding, the applicant has satisfactorily demonstrated that the threatened upland sandpiper is not present in and is unlikely to reoccupy areas that DEC had previously identified as occupied habitat pursuant to the state endangered species law. This conclusion supports a finding that the construction of the 4 turbines in that area will not result in any take of upland sandpiper occupied habitat and thereby eliminates any need for a net conservation benefit plan to address that formerly occupied habitat. Accordingly, the order concludes that the project will comply with all applicable state and environmental laws and that the environmental and operational impacts will be avoided or minimized to the maximum extent practicable. My co-presiding examiner, Judge Greg Sayer, will now briefly address other issues discussed in the draft order. Judge Sayer.
Thank you, Judge. Good morning, Chair Rhodes and members of the Siting Board. I'm going to address 3 hotly contested issues in this case: the outreach to the Amish community, whether the project is a beneficial addition to the state's generation capacity, and compliance with local laws. The towns of Freedom and Farmersville took the position that the project should be rejected because there was ineffective outreach to the Amish community in Farmersville. There is a separate Amish community in another town, some members of which signed participating leases, but no one in the Farmersville community signed. The draft order before you notes that in addition to the usual meetings, mailings, and newspaper notices, Alley Cat met face-to-face with members of the Farmersville community at one of their residences and discussed the project and took the concerns raised by the Amish representatives. Under these circumstances, the draft order finds that outreach was sufficient for that community to become aware of the project and to participate in the project or the proceeding if they chose to do so. I'll turn to the issue of whether the project is a beneficial addition to the state's generation capacity, which is one of the findings required by the Article 10 statute. The Concerned Citizens Coalition argued that the project will not be a beneficial addition to capacity because transmission bottlenecks between upstate and downstate will, if not resolved in the future, bottle up the capacity of the Alley Cat project and cause its output to merely displace the output of other upstate wind projects, thus not adding to the state's generation capacity or clean energy goals. The draft order rejects this position. It acknowledges that there are transmission constraints that will need to be addressed in the future, but determines that the need to add transmission in the future is not a reason to reject new renewable energy projects now. Requiring transmission to be built before a generation project is approved would be putting the cart before the horse. Transmission must be expanded in the future, but to do that economically, the Public Service Commission and the independent system operator need to know where the generation sits. The draft order also recognizes that the transmission constraints are being addressed in compliance with the recently enacted Accelerated Renewable Energy Growth and Community Protection Act, which provides for expedited transmission upgrades. The draft order therefore includes the finding that the project will be a beneficial addition to the state's generation capacity. One of the most hotly contested issues in this proceeding is the application of local laws. And I'm sorry for the length of this presentation, but please bear with me because it's very complicated. Under the statute, the Siting Board applies substantive local laws to projects, but may decline to apply any local law provisions that it finds to be unreasonably burdensome, with the applicant bearing the burden of proof if the law is unreasonably burdensome. In this case, the local laws in the towns of Freedom and Farmersville have changed a number of times, complicating the situation. I'll start with the town of Farmersville. It was uncontested at the time of the hearings that Farmersville 2019 local law regarding wind projects applies. The 2019 law has setback requirements between wind turbines and various types of properties, with a much larger setback requirement for churches than for residences. In this proceeding, the town argued that all Amish residences are churches because the Amish community holds worship services on a rotating basis in the homes or barns of its households. The examiners rejected this argument as unpersuasive in light of the fact that any particular residence on a rotating basis would host a worship service only approximately once every 10 months. The draft decision agrees with the examiners. The town argues that its interpretation of its own law must control, but the draft order states that it is up to the Siting Board to interpret the law in this case, and that the Siting Board is not bound by the litigating position that the town takes. The town of Farmersville made a number of changes to its local wind farm laws after the close of the hearings. Local law number 1 of 2020, which contains many substantive changes and stated that it superseded the 2019 law, was enacted on February 10th, 2020, 2 months after the close of the record on December 5th, and 10 days after the filing of the reply briefs to the examiners. Farmersville enacted yet another substantive wind farm law on April 13th, 2020, which purported to supersede all prior local wind farm laws, including the February 10th, 2020 law. This occurred 3 days before the filing of briefs opposing exceptions, the final round of briefs to the Siting Board in this case, and more than 4 months after the record closed. The draft order before you declines to enforce these new local laws because they gave the parties, the examiners, and the board no reasonable chance to litigate the issue of whether some or all of these laws are unreasonably restrictive. To fully air those issues would require a request by LCAT for an override, testimony on that request, including a rebuttal round, hearings, briefs, reply briefs, a decision by the examiners, briefs on exceptions to the Siting Board, and briefs opposing exceptions. The town enacted its legislation far too late for this process, and the statute requires the Siting Board to make its decision based on the record. The town argues that the Siting Board could have extended the proceeding under the statute for up to 6 months. However, even if the board did so, possibly with serious repercussions to the project due to the long delay, nothing would prevent a town board opposed to a project from enacting yet another piece of restrictive legislation near the end of the extension, leaving the Siting Board with no time at all. The draft order before you therefore follows the Siting Board decision in the Bluestone Wind proceeding that it will not apply local legislation enacted after the close of the record in the proceeding. In this case, the record closed on December 5th, 2019, and the legislation in February and April of this year is not timely. The draft order also rejects the argument that the Siting Board has no choice but to apply whatever legislation is in force at the time of the Siting Board's decision, with apparently no discretion and no record to determine whether the legislation may be unreasonably burdensome. That argument is rejected in the draft order because it would make a town's decision paramount over the Siting Board's jurisdiction, which is inconsistent with the statute. I'll turn to the town of Freedom. And the issue for Freedom is which wind farm local law to apply, one enacted in 2007 and the other, which was less restrictive, in 2019. LCAT took the position that the 2019 law applies and did not request any overrides of that law. The 2019 law was essentially a duplicate of a local law enacted in 2018. The 2018 law was challenged in a court proceeding, and a court order in October 2019 invalidated the 2018 law on procedural grounds. That court decision was ultimately upheld. The 2019 law is also subject to a court challenge, which at this point is unresolved. The examiners applied the 2007 law. The draft order before you reverses that decision and applies the 2019 law. Again, following the Bluestone decision, the draft order recognizes that the citing board must make its decision on the basis of the record, and the record shows that the 2019 law was in effect when the record closed. Both the towns of Freedom and Farmersville passed a series of resolutions on January 6th, 2020, a month after the record closed. These resolutions, although they substantively address wind farms, were not enacted as local laws and do not have the force of local laws. And for those reasons, as well as the fact that they were passed after the record closed, the examiners declined to consider them. The draft order agrees with the examiners on this point. That concludes my part of the presentation, and we welcome any questions.
Thank you. This is John Rhodes. I hope I've unmuted. Can someone please confirm that they can hear me?
You're good, Judge.
Thank you very much. So thank you very much, Judges LeCakes and Sayre. My own comments are to support your findings. In these cases, we have to consider all the topics that you raised: environmental, public health and safety, concerns of the community, species preservation, etc. And I appreciate and applaud the careful and study and investigation of the potential concerns in this case, and then the resulting findings and recommendations that really do lead to avoidance, mitigation, minimization to the maximum extent possible. I appreciate also the very transparent discussion of the three prominent, as you said, Greg Sayre, hotly contested issues on the Amish community. I appreciate and am persuaded by the finding of fact on the question of the beneficial addition to the generation fleet. I support the conclusion, just as a matter of how the system is coming into being, and as really guided by a couple of the statutes that you mentioned. And I just note that the local laws are always, the topic of local laws are always difficult. They're always complex. And I find that in this case, the recommendation is judicious, it's correct, it's fair, and it's faithful to the record. And more broadly, I just appreciate the steadiness of the rulings that this citing board is making, where from case to case, we maintain the same standards. I think that's simply a matter of good practice, and it's good for outcomes, and it's good for the process. So I'm going to support this item. Thank you very much. Let me ask my colleague, citing board members, if they have any comments or questions. Given that it's a conference call, what I will do is call on you by name, and you will either have a comment or a question, or tell us that you don't. And then I'll proceed to call for a vote with the same mechanic. Any comments or questions from Mr. Alexander?
I found the proposed order to be comprehensive. I have no questions.
Thank you very much. Dr. Lewis Michael.
I have no questions.
Thank you. Mr. Ravishir.
No questions.
Thank you very much. Mr. Williams.
No questions.
Thank you. Mr. Mueller.
No questions.
Thank you very much. With that, I will proceed to call for a vote. My own vote is in favor of the recommendation to approve the application of Alicat Wind Energy LLC for a certificate of environmental compatibility and public need as just described. And for good order's sake, I confirm it's John Rhodes casting that note in favor. Mr. Alexander, how do you vote?
I vote in favor.
Thank you. Dr. Lewis Michael, how do you vote?
In favor.
Thank you. Mr. Ravishir, how do you vote?
In favor.
Thank you. Mr. Williams, how do you vote?
In favor.
Thank you. Mr. Muller, how do you vote?
In favor.
Thank you very much. The matter is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
This is Secretary Phillips. There is nothing further today.
Thank you very much. With that, I adjourn us and wish you all the best, and please everybody stay safe. Thank you.